Now, Malas, let me disabuse your lordships of some of the myths that have been portrayed here. Number one, that Parliament has plenary powers under 370. Just the contrary. The power of Parliament to make laws is limited by 370.
There are limitations on Parliament's lawmaking power because...
No, not that.
Yes.
That I'm not saying that. I'm saying something different. It is a limitation on the Parliament to make laws to matters in the union list, to matters in the state list, in the concurrent list. It stares you in the face, and you're talking about plenary power. Where is that plenary power? If you want to pass any law, or if you want to extend the provisions of the Constitution of India, forget about 371 B1 and 2. Look at D. If you want to extend the Constitution of India in respect of matters which are in the instrument of accession, outside of those matters, you have to consult, otherwise you have to take concurrence. And how does the President of India act? On the inner advice of the Council of Ministers. President is not acting in his individual capacity. It is the Council of Ministers which will decide, not Parliament. The Governor acts on the aid and advice of the Council of Ministers. It is the Council of Ministers at the other end which will decide, not the legislature. It was to ensure that there is slow integration of Jammu and Kashmir into India through a process that is easy, through a process that will allow the executives communicating with each other to make sure that the Constitution of India, as applied to the Constitution of Jammu and Kashmir, is put into effect. Which is why the CO in 52, in 54, that's the background. Once we decided on the list that this is the entry in the list on which a law can be made, and two executives agreed on it, a law is made and it will be applied. That's the procedure, Malaj. Nothing to do with how they have interpreted the Constitution. And that's how it happened all the time. Which is why, if your lordships will remember at the outset, I said, this is an exercise of executive power. It is not even exercise of legislative power. Far be it some quasi, some ancillary constituent power. Doesn't exist. Yeah, Malaj, I am asked this one question for which, Malaj, if you have an answer, Malaj, I certainly don't have an answer. Malaj, throughout, Gopalaswamy Iyengar, who was part of the drafting committee and who introduced the bill, understood 370 as we have argued before your lordships. Exactly that. From 1950 to 5th of August 2018, no member of parliament, no member of parliament, no individual in the public space said otherwise. Nobody said it. Every interpretation of the Constitution as reflected in the debates in Legislative Assembly and in Parliament interpreted the Constitution as Iyengar interpreted it and as we have argued before your lordships. There has never been a dissent. When the government of India files an affidavit in this court, it's the same thing, except they say that now through this process, we have substituted the Constituent Assembly with the Legislative Assembly. They have understood 370 in the same way. Now in the argument, not part of their affidavit, not part of their pleadings, they say, no, there is some plenary power. Your lordships are not sitting here in an advisory capacity to tell them as to what 370 means. We are, Malaj, testing the action of the union. We are not having some academic exercise of the interpretation of 370. We just to test CO 272 and 273, whether it was rightly done or wrongly done. Maybe rightly done, maybe wrongly done, that your lordships will decide. But it has nothing to do with any plenary power, nor is it the case of the union. Now, let's accept their argument. Let's see, test it, Malaj, how it will be. They say, this is a plenary power. Forget the proviso, because the Constituent Assembly is dead. There is no Constituent Assembly now. There is a Constitution of Jammu and Kashmir which is in place. And the argument is, now that it is dead, I can exercise that power and abrogate it. That's always been the position. So what it means is, Malaj, that the Constituent Assembly and the people of Jammu and Kashmir signed their death warrant on the day the Constitution was made and the Constituent Assembly was dissolved. On the next day, 370 could have been abrogated. Instead of 5th of August 2018, 19, they could have abrogated the next day. So they were signing the death warrant. That while we are there, you can't do anything about it. But the moment we have drafted the constitution of Jammu and Kashmir, then you can tomorrow just take away. Just abrogate 370. What can any constitutional court can ever interpret 370 in this fashion? Can anybody even think about it, Mullah? That a constituent assembly drafting the constitution of Jammu and Kashmir, saying that we are an integral part of India, taking note of 370 in the manner in which it is to be integrated into India, will say to themselves that the day we are not in place, it will be abrogated because there's a plenary power superior in 370, which is not there in 370, but because we say so, and which is not even part of the counter affidavit of this. This is not even the case of the union. What are we? Wait, this is not some. I mean, this is not even. You look at it textually. You look at it contextually. There is no other conclusion you can come to. Now, your lordship asked me several times and asked others also, what's the way out? That's not for your lordships to decide. Your lordships are not here to tell them what the way out is, or for us to tell them what the way out is. It's a political process. The way out is a political process. Or some other process, that's for them to decide. But the way out is not this, that you do something consistent with the interpretation of 370, and you argue exactly something else, which has nothing to do with your own counter affidavit, and that's the union. How can they be allowed to do that, Minister? What does concurrence mean? It means consent, as your lordship has been saying. If it requires the consent of the governor of the council, governor acting on the aid and advice of the council of ministers, where is that plenary power that we are talking about and reading in 370? And 370, sub-article 2 says that if an order is made, Mullah, between 1950 and 1951, when the Constituent Assembly was in place, the Constituent Assembly can reject it.
Mr. Sibal, why does the proviso to clause 3 use the expression recommendation when two other provisions in the same article use the expression concurrence?
Yes, sir. I'll give your lordship that.
B2 uses the expression concurrence, and the second proviso to D uses the expression concurrence.
Absolutely. In other words, Mullah, when it comes to applying the Constitution of India to Jammu and Kashmir in respect of in matters which are not with reference to the lists, Mullah, you need the concurrence of the state government acting on the aid and advice of the Council of Ministers. At least, Mullah, that there is no plenary power of Parliament. Concurrence means I can say no. Means an executive can say no to what is proposed. Now, if you read 370, and I just answer my Lord's question, if you read 370, the president's still notification cannot be initiated because the expression in the proviso to 370 are two expressions, necessary and before. The timing is set before the president issues a notification, a recommendation has to come, and that is necessary. And the order in which is that the recommendation will come, then you would pass an order. You can't reverse that process on a plain language, on a textual reading, which I said, Mullah, I accept what Mr. Salve said. Read the text and give the answer.
Mr. Sibal, is it not conceivable? I mean, I'm just thinking aloud.
Yes, sure.
That so long as Article 370 operated, it provided modalities for the application of the lists, the entries in the 3 lists, consultation in one case and concurrence in the other.
Right.
So long as Article 370 operated, it provided for the application of the other provisions of the Constitution, subject again
to the same process.
Same formula, consultation and concurrence.
Absolutely.
You probably rightly said that the object was to bring about a slow integration.
That's correct, which I've been saying.
In achieving that slow integration, the Constitution framers provided for consultation, this whole formula of consultation and concurrence.
Absolutely.
Checks and balances at 2 levels of government, the union government and the government of the state. But significantly, The constitution doesn't tell us what would happen after the constitution of Jammu and Kashmir would be framed. It contains no express provision that that constitution would then be embodied or incorporated in the Indian constitution. Because the Indian constitution, by all indicators, we've seen several indicators, was always to reign supreme. So when it came to abrogation, it left in 1950 the point of abrogation to the exercise of wise statesmanship. You just said a short while ago, why didn't they do it in 1950?
No, not a question to do it. They had the power to do it. I'm not on that.
You're right. Yeah. I mean, you're right. Yeah. Why did they not do it? They had the power to do it. If they had the power to do it,
because they never understood 370 in this fashion.
No, there's an alternate hypothesis. It was always presumed that allow 370 to work out. There should be an eventual process of integration. Let that integration take place over a period of time, during which you will have this twofold procedural check of consultation and concurrence. At what point of time the integration is deemed to be complete, or that Jammu and Kashmir is ripe for an integration with the rest of India in the full and true sense of the term, was not hedged in by the constitution.
Mullahs, I'm sorry, with the greatest respect.
Is that not a possible?
No, it's not. It's not, Mullahs, on a plain reading of 370.
Because there are very significant silences in Article 370.
Mullahs, you don't need expression of interest in this fashion, for the simple reason that that 373 itself gives you a clue as to what was the reason.
There are not sufficient silences in Article 370 to lead to the conclusion that the framers, both when they were on that side in the state of Jammu and Kashmir and on this side in the Union of India, left it to wise acts of statesmanship in 1950.
I hope on both sides, Mullahs.
Yes, of course.
This was a unilateral act, Mullahs. This was not a wise act, it was a unilateral act.
Just one, taking on what Chief Justice just said,
yes.
It's quite apparent at that time what was either happening with the rulers and integration into India, because that was our objective. And it was all a political move at that time. There were different views expressed even with regard to J&K. If one looks at the wording of the articles, the argument of the other side was it was deliberately left very flexible and to some extent contradictory.
Mullahs, I don't see the flexibility here, Mullahs, neither I see the contradiction. Just read 3 with me, Mullahs. If you find, Mullahs, that there's a silence there about what would happen, Mullahs, certainly.